Hello, PSI2000 students, back for week 4. In this week, we begin to shift from some of the founding concepts of political science and the founding concepts of Canada and the Federation to some of the structural aspects of Canadian political landscape, starting, of course, with the Constitution, which is the topic of this week, called Canada's Constitutional History from the BNA Act to the Patriation and the Charter to ? Because some would argue that we still have unfinished constitutional business in Canada, whereas others argue that the Constitution is in pretty good shape. Now, you need to understand the significance of a Constitution, which of course is the master or the predominant law of any country, is a democratic country, is the Constitution. The Canadian Constitution has really started before 1867 in the British North American Act, North America Act, which is the BNA Act, which basically defined our governance with respect to the British Empire at the time in 1867. Now, but the Constitution was not just the BNA Act, of course. It's comprised of a number of different factors that a Supreme Court judge would tell you constitute the Canadian Constitution, including previous court decisions, conventions, and so on in common law, as well as the BNA Act. But of course, in 1982, we, as Canada, patriated our own Constitution, which gave us a separate Constitution from the British North America Act. Now, that the BNA Act is still a factor in our Constitution, just as the conventions and previous court decisions provided for. But the Constitution, having been patriated, was written into law in more significant ways, including, of course, most fundamentally, the Charter of Rights and Freedoms in Canada. It's also important to understand the different historical periods and how they influenced our Constitution. In 1867, a major concern for Canada and its Constitution was collective rights, the rights of the French vis-a-vis the English, and then federal and provincial rights, the division of powers between levels of government. And that tended to dominate a lot of what our Constitution was in those early periods. But you have to recognize that constitutions have evolved over time to not only define the rights of governments vis-a-vis other governments, but increasingly to define the rights of individuals with respect to the power of governments. And so Canada made that significant transition with the adoption of the Charter of Rights and Freedoms and with the patriation of the Constitution in 1982. Suddenly, Canada's Constitution, the weight of Canada's Constitution shifted from expressions of rights between governments and rights between collective groups, like the French and the English and so on. It shifted to one of individual rights vis-a-vis all forms of government or all forms of the state. And that was a major transition. That was a major transition in Canada as a country. Not only because we have our own constitution now, but because of the nature of that constitution, how it transformed our politics with a greater emphasis on articulating individual rights in addition to collective and government division of power. Type factors. And with the advent of the Charter of Rights and Freedoms, of course, became a much more significant role for the courts in determining and interpreting those rights and freedoms vis-a-vis the capacities of the government to influence those rights and freedoms or infringe on those rights and freedoms. So people need to realize that modern constitutions are much less about governments now defining their power and their division of powers, and much more about the division of power between the state's capacity to infringe upon the rights and freedoms of citizens. And the Canadian Constitution was brought into line with that essentially in 1982 with the patriation of the Constitution. Now, that doesn't mean that the citizen rights didn't exist before the Charter of Rights and Freedoms in 1982, but they became enshrined and much more clearly articulated in the Patriation of the Constitution in 1982. So what did this do to the emphasis of collective rights as opposed to in the pre-82 period as opposed to the post-82 period? Well, it brought into starker contrast the often complex relationship between collective rights and individual rights because for example, we saw that in Quebec language laws and the sign law in Quebec, for example, where the collective right to protect a language and to protect a cultural identity could starkly come into contrast with an individual's rights to have free expression, including on commercial signage. So the courts have had to rule on issues of where individual rights have come into conflict with collective rights and where individual rights and collective rights have come into conflict with government power to potentially infringe on those rights or to scope those rights or to define them in a certain way. And so constitutional politics is a very, very, because it is the highest law in the land, is a very critical aspect of all political systems in liberal democratic governments that run by the rule of law. So it's important for when you read through the week's readings, that you understand how the constitutions are constituted. The original 1867 Constitution of Canada, how that constitution was formed, what it was comprised of, what it tried to do, and how that became transformed over time in 1982 with the patriation of the Constitution, but perhaps likely most significantly, the definition of the characterization of individual rights and freedoms relative to the power of the state, and how that transformed the role of the courts, for example, in interpreting those things. Some political scientists have argued that the courts have become too powerful because the Charter of Rights and Freedoms gave them authority to define or to use the rule of law to determine what was acceptable use of state power. Whereas others argue that the Charter is just about right. It's not easy to change. It's not impossible to change. It struck a good balance. Whereas others would argue that the Charter didn't go far enough. But of course, in any situation where you're defining the paramount law of a country, there's going to be this divergence of views. But from your perspective is to understand how the Constitution constituted Canada in 1867, but how that became transformed over time from government division of powers and collective rights to much more clearly the patriation of the Constitution, which gave us separation from Britain, but also gave us an injection of what we would call individual rights and freedoms politics into our constitutional milieu, such that it transformed the way governments must act, and that it transformed the role of the courts in our political landscape. And I don't think anybody would argue that individual rights and freedoms aren't important. Obviously, that would be a 99.9% held view. But how it was done, there's still ongoing debate, and whether the constitutional challenge for Canada is finished. Or do we still have more things to do? Are there some things that we should have done better? And what do we do with Quebec in the Constitution? As you know, there were two efforts to try to change that, to address that. It was Meach and the Charlottetown Accords. Both failed because they didn't meet the amending formulas in the 1982 Constitution, of which there's more than just one, which is often misunderstood in the press. There's a unanimous requirement for amendments, but there's also other formulas that come into play. You'll see that in my written notes for the week, and you'll also learn about that in the readings. So understanding the impact that the Constitution had on Canadian politics is very important, particularly in the last 30 years or so. And so you need to have a good understanding of that. You need to have a good understanding of how the patriation of the Constitution and the Charter of Rights and Freedoms transformed the role of the courts in Canadian politics after 1982. and how individual rights became a challenge for collective rights and vice versa. And when you define a collective rights, I gave you the Quebec example. It's the right of a collective identity to sustain itself against the power of other collective identities or the state. But individual rights is your right to be treated according to all of the rights and freedoms in the Charter, vis-a-vis the power of the state, or vis-a-vis the power of any other collective identity. And you could see how that would change a lot the dynamics of our constitutional politics, and it would change a lot the pressures put on the courts to resolve disputes around these things. And we see that all the time. We see that with appeals to the Supreme Court over all kinds of things that look at the relationship between collective and individual rights, and look at the relationship between the power of the state and individual and collective rights. And so to understand the structures of Canadian politics, you obviously need to start in a society that runs by the rule of law, like Canada's Liberal Democratic Society does. You need to look at the politics of the supreme law of the country. So in your readings, think about those issues as you go forward, and we'll see you again next week. Cheers.